I'm going to transition us to our next topic, that is to understanding now some of the science behind ESI, how that interplays with our rules of court, and in particular the rules of civil procedure. So for that purpose, Judge Kirpalani.
Thank you, Mark. As effective January of 2014, Massachusetts courts crawled into the modern era with the amendments to the Mass Rules of Civil Procedure, the discovery rules that acknowledge the existence of ESI and set forth principles for managing the discovery of ESI. So now this is obviously a very broad topic that I can't do justice to in a short time, but I do want to highlight some of the key concepts that happen when you're in a litigation in Massachusetts, and also highlight perhaps some differences between federal and state practice, because there are some differences that are material. So, my slides up? Okay. And so the first one is the so-called ESI Conference. If you're familiar with federal practice, you know that there's a mandatory ESI conference in every civil case. It's mandated by Rule 26, and so the parties need to get together and act consistently with that rule. In Massachusetts, it's not mandatory, so you have to ask for it. So if you ask for it within the first 90 days after a response, the first responsive pleading is filed, you get it, meaning the other side must sit down with you and go through the topics that are required for discussion, and I'll get to that in a moment. If it's after the 90 days, then you must serve a request on your opponent or on all parties to have a conference. If 30 days after that there's no agreement between the parties to conduct a conference, that requesting party may move for a Rule 16 conference regarding ESI. And of course, one of the amendments to Rule 16 provided that the court may require in a Rule 16 conference the parties to consider things such as the preservation and discovery of ESI. So again, a key point is if you don't ask for it, you may not get it. What happens at an ESI conference? Well, it's the parties, the court's not involved, and the Rule 26 mandates that there are 8 topics that must be discussed. These are all threshold issues. There's rarely resolution at this point, but it's all towards an eye of coming up with a plan for managing ESI in the litigation. So issues about the preservation of data must be discussed. The form of production in the future must be discussed. Whether and how metadata may be produced is discussed. The time within which the production will be made is discussed. The manner in which the assertion of any privilege issues or confidentiality, proprietary information issues must be discussed. If there are any allocation of expense issues attendant on the production of ESI, they must be discussed. And then lastly, the 8th topic is a catch-all, any other issue. So what happens is the parties have to sit down within 30 days of the agreement or the demand and go through these things. And the next thing they have to do is come up with a plan if there's been an ESI conference. And so within 14 days of the conference taking place, the parties must draw up a plan, and it is addressing their agreement or disagreement on the 8 topics that they are mandated to discuss. And this must be filed in court along with a statement regarding any agreement or any disagreements with parties' views on the plan. So the next thing that is worthy of noting that following the ESA conference, the court may issue an ESI order, and there are 5 ways this may happen under the new rules in Massachusetts. First, after the parties file an ESI plan, the court will issue an order addressing their plan, and in particular any disagreements. After any Rule 16 conference, the court, where the court has directed the discussion and consideration of ESI preservation and discovery issues, the court will again issue an order, and upon the motion of a party, the court may issue an order. If the parties stipulate and ask the court to issue an order, the court will probably issue an order, and the court can do it sua sponte, that is on its own, if it occurs to the court. So what's in the ESI order? Well, not surprisingly, 8 topics, the same 8 topics that the parties were mandated to consider when they had the conference. So I'm not going to go through them again, but they're the same as the last slide. And then 2 additional issues the court is supposed to address in this ESI order is, one, whether discovery of ESI is reasonably likely to be sought in the first place. And I would suggest the answer to that is probably yes, or you wouldn't be doing this. And second is an ability of the court to address, even at this early stage, because we haven't really started the discovery yet, the permissible scope of discovery if the court has been able to divine or glean some principles that ought to govern the case going forward. So now another significant difference in state practice with federal is, of course, in Massachusetts state courts, we have no mandatory disclosure in civil cases. Ever since the so-called Expense and Delay Reduction Act was passed by the federal government, we've had mandatory disclosure in civil cases, and I always quibbled with the description of expense and delay reduction, but what it means as a practical matter is if you're in federal court, and I'm just departing from state practice for a moment, you've got to address ESI on your own, before you even get into discovery, because I forget exactly how much time you have to do to mandatory disclosure, but it's early on and up front, and any ESI that has to be disclosed or produced that may be used to support your claims or defenses. So that narrows it, but what it means is if in your federal court, you have to start wrestling with this on your own before you've even been asked. So it doesn't happen in Massachusetts, however. Massachusetts has often lagged behind the feds in adopting new changes to our rules of civil procedure, and I have some personal knowledge that our conservatism in that regard is because many people are leery of the success of mandatory disclosure in the federal system. So now I want to talk about one last issue which relates to discovery and limitations on discovery for ESI. And the first is what we call inaccessible ESI, and I think the lawyers are probably going to talk about that in a while when I stop talking. But first of all, it's defined in the rules as something that is not reasonably accessible because of undue burden or cost, or in other words, and you may object to production on that basis. So that's the party's way of saying, we don't think we have to do this because it's a pain. That is that's an objection that may be made when it's made, and then if there's a motion practice following this, then the burden is on that objecting party to prove inaccessibility. And of course, because it hinges on burden and cost, obviously there's a lot to talk about. It's important to note that both in the state and federal system, even if it is determined to be inaccessible, that is unduly burdensome or expensive for that party to produce, in Massachusetts state practice, the court may order it nonetheless if they do a benefit outweighs the burden analysis, which, and I've set it out in the slide, the considerations that are taken into account are the amount in controversy, the resources of the parties, how important the issues are, and the importance of this discovery in resolving the issues in the case. So that's how the Massachusetts rules deal with it. Federal rule is slightly different because the essential difference is the court can order inaccessible ESI to be produced upon a showing of good cause, whatever that means, but the court also must limit the discovery if it goes through an analysis that is set forth below. That is that the discovery sought it's unreasonably cumulative or duplicate, could be obtained from a more convenient, less expensive source. If the party already had ample opportunity to obtain the information by discovery, presumably alternative forms of discovery, or it's outside the scope of what Rule 26 permits in the first place. So in the federal system, that is ostensibly, the judge is required to go through that and not to compel the discovery if it finds these factors exist. In the state practice, and I don't have a slide for this, Rule 26B4E sets forth that exact same analysis, but also adds something to it, which is that the court may limit the frequency or the extent of discovery into ESI, even if it's accessible, if it goes through those factors and comes out the same way, that it's unduly cumulative, duplicative. There was also an ample opportunity to get it some other way. And lastly, whether the burden of expense outweighs the likely benefit. So these kinds of cost-benefit analyses are done by the court in determining whether, in Massachusetts, whether even accessible ESI must be produced, and certainly with respect to inaccessible ESI, where obviously there's a good chance the burden and the expense have all gone up. So.
One of the issues that the appeals court has at least been addressing most recently, and one of the important issues for lawyers, is the so-called clawback provision of Rule 26, B5, I believe it is, relative to claims of privilege, and that is to say information which has mistakenly been produced under a claim of privilege. We'd like just to identify that particular provision and speak briefly about it. Judge Kirpalani, please.
So in Mass Rule Civ P26B5B permits a party to assert a claim of privilege or protection with respect to things that have been inadvertently produced in discovery. And we all know when we're dealing with this ESI that it's not that hard to inadvertently produce stuff in a massive discovery. In fact, there was a recent decision out of the BLS by Judge Kaplan where there was an inadvertent production of privileged information in a large ESI production, and Judge Kaplan, and I've cited it in the written materials on the case abstracts, went through a detailed analysis of how difficult it is to stop this from happening, and the appropriate remedy is to claw it back. So, and that's what he ordered in that particular case. So it's pretty much the same as the federal practice and the federal clawback provision. So I hope that answers your question,
Absolutely.
Judge Mason.
Absolutely. Yes, Andy.
Well, yeah, one point on that. The federal clawback provision, I believe, authorizes a joint order, which you can have entered in your case. Shannon's nodding, so I'm feeling more confident now. Which will say, inadvertent disclosure is not a waiver of privilege in this or in any other action. Mm-hmm. So you are not only protected in the case at hand, but you are protected from some non-party claiming down the road that there was a waiver. And it's an easy order to get. Mm-hmm. Ever a reason not to get that in federal court?
Absolutely not. In fact, one additional practice point to consider on that, and it's under Federal Rule of Evidence 502, where you can enter into a 502 agreement and get it entered as an order. And there's two provisions to keep in mind. There's 502B and 502D. And I'm going to get them backwards, and I always have to look it up. But one is better than the other. And here's why. If you enter into an agreement with your opposing counsel and you want to enter into a 502 agreement, it's either B or D. You pick one where you do not have to show inadvertent. You can just say, we have a 502 agreement. If I produce a privileged document to you, you have to give it back. You don't have to use the word inadvertent in there. And why can that be troublesome, right? If you have to litigate whether something was inadvertent, well, then you have to open the door to your review process and talk about all the things you did to prove that the steps you did to avoid waiver were reasonable. Now, you don't always get that agreement. You don't always get that sort of blanket protection of a straight-up clawback, don't even have to show inadvertent. But I would say we get them about 50% of the time, and it certainly cuts down on a lot of discovery disputes and motion practice, and it can save clients a lot of money.
Yeah, I actually have a 502D order entered by, I have a D order entered by Magistrate Judge Peck out of New York, who is now retired, but who has done a lot of work on e-discovery. It basically says the privilege, production of privileged or work product documents, ESI, whether inadvertent or otherwise, is not a waiver of the privilege or protection from discovery in this case or any other federal or state proceeding. So the order shall be interpreted to provide the maximum protection allowed by Federal Rule of Evidence 502D. So I can get that to you if we're going to circulate some stuff afterwards. And any federal case, you should consider that.
Well, let's continue our discussion of disclosure obligations, and perhaps I'll turn to Shannon and Andy to talk about what other disclosure obligations counsel will maintain, for example, in authenticating discovery which has been produced, and so on and so forth. And then let's dive into a discussion about dealing with inaccessible data, something that I think that is oftentimes the subject matter of motions for motions to compel. And we can turn to our entire panel for that purpose. But first, let's talk about some attorney disclosure requirements.
Basically, you want to, in your role as an attorney, just as a matter of competently representing your clients. And in that connection, the ABA rule I cited earlier, which is ABA Model Rule 1.1, which imposes the general rule of competent representation, and its comment 8 to that rule that was amended in 2012. It used to read, to maintain the requisite knowledge and skill of lawyers should keep abreast of changes in the law and its practice, engage in continuing study and education, and so on. Well, what was included there was including the benefits and risks associated with relevant technology. So if you're a civil practitioner and you are not at least, and you're a litigator, and you're not at least minimally versed in how modern information systems create and store information, it is very difficult, I would submit, and I think everybody on this panel would agree, to competently represent your client. So even in advance of litigation, in anticipation of litigation, preservation is critical, as has been discussed. When you dive into the actual process of crafting your own discovery requests, you need to do that immediately, and you need to do it thoroughly. And immediately, because as Shannon pointed out, there is volatile data that you want to get, and you don't know what the records retention policy of the entity that you're seeking discovery from is. They may not keep records for long. All records may be in the cloud, and they may have to do a specific request. So you need to act quickly and get your discovery requests and preservation requests out there. And the same is true in anticipating what the other side's request will be. You don't want to be the lawyer who didn't advise his client or her client to properly preserve evidence. You could go in and say, yes, evidence existed, but it was destroyed 3 days after the complaint was filed. They just, you look, it's a bad look these days. You want to advise your clients in anticipation of litigation, and certainly once litigation has started, as to, preservation of all material potentially relevant to the action and potentially discoverable. So I think the key thing is hit the ground early on e-discovery. Those old files that we used to ask for back in the day, those weren't going anywhere. But electronically stored information is a very different animal.
Yeah, so I think if we're talking about the attorney's role here in disclosures and framing discovery, I think a large part of our job is, as Andy is saying, is to understand what are we even dealing with, have I preserved everything? But then when we move into the advocacy role, right, it's really being aggressive. And I don't mean aggressive as in confrontational. I mean aggressive in knowing what you have and knowing what the costs are going to be and trying to find ways to work with your opponent and the court to make it less burdensome and costly, et cetera. So a couple of ways I think we should be thinking about doing that in terms of e-discovery and technology is, first of all, depending on the type of case, seeing if it can't be phased, right? Can discovery in this case, dealing with the different data sources now at this point we know we have, can we phase it and will the court accept that? Is that a good logical way of judicial resources and party resources? I do think that it would be wonderful if more cases embraced phasing of discovery. What happens now is we jump all in with all the ESI, all the database, all the everything right away. And I do think that there's a lot of inefficiency a lot of times in some of that. Another thing I think that we can be really good at in an advocacy role and also as a good opponent is taking the request for production of documents and being really thoughtful about them. And you know what? The rules in the case law require us to do that now anyway. It is no longer okay to do your boilerplate objections, I hope my judges agree, and to just basically say nothing, right? Like, here's my 12 pages of objections, and for each RFP, I restate all my objections, and I'll produce something if it's relevant. That's, you know what? First of all, it's not allowed anymore, but second of all, you're not embracing and taking control of the situation in a way that can help your client, right? So what would be better is to take each RFP, identify what specifically is truly objectionable about it, and then say, with as much specificity as you can, what you really will produce or won't produce. So for example, I like to try to guide our attorneys to break up the RFPs into three categories. One, what's totally objectionable? No way, we're going to give you 0. Okay? If we're going to do that, state what the objections are and do not add that little clause at the end. Notwithstanding these objections, we will produce it. No, don't even say it. Just don't even say it. Just object. The second category is which RFPs call for specific low-hanging fruit documents that don't require email review, right? So specific documents or sufficient to show documents. What RFPs are those? Do your whatever objections, and then specifically, we will produce XYZ sufficient to show blah, blah, blah. Or we will produce contracts dated 1974 to the present, period, full stop, end of answer. And then the last category would be what I call the all ESI RFPs. And so those are the ones where the money comes in. And that's where the negotiations really hit the road, right? Because that's the one where hopefully if you're working on, as the judge was talking about, your ESI agreement and protocol, you will talk about scope. You will talk about number of custodians. You will talk about whether or not you're going to have a date range call or a custodian call, whether or not you're allowed to use predictive coding. That's where those RFPs matter, right? And for those, I still like to try to be specific, right? Even though I know I've got an ESI agreement or protocol backing me up, I still like to try to say, these are my objections. We will search the agreed upon custodians pursuant to the ESI protocol in response to this RFP, right? So I think that to me is what the advocacy attorney role is with respect to electronic discovery and e-discovery. I mean, there's obviously a million other things involved, but those, I would say, are the big ones.
Yeah, I would say so. I think the other one on our list is, well, in what format do we want the discovery, and to what format do we produce our discovery? Either one of our experts could probably talk better about that or give you more information than we can. So, what do you think? In other words, when you're crafting a discovery request, how is it you make sure to get the information in the form will be most helpful to you?
So, in terms of producing the documents or getting over the production, the two real, and I'll bifurcate into two options, and there are various flavors of them. You could either do a native production, which is to say, give me the document in its native form, so produce to me an Excel document or a PowerPoint document, or produce to me the actual MSG file, which is the container individual email for Outlook. Or the other option is to get it in TIFF format with specific metadata associated with it. I think the standards on that has evolved over time, but I think it's always still, at least what's prevalent, and maybe Shannon, you have a better view on this, is for things like Excel and other documents that have a lot of data that can be searched through, we're seeing a lot more prevalence of doing native productions for those, and then it really becomes how you're going to control that here's the MD5 hash, or here's a unique identifier so I know it's not been changed after it's been produced natively. And then everything else gets produced in a standard agreed TIFF format with specific metadata associated with it. Some of the nuances you'll run into when it comes to TIFF is what should be in color versus what should not, because specific presentations sometimes make sense to view it in color because they give a different story. So there's just different nuances. But I think the main thing you want to first consider is, are you asking for a native production or a TIFF-based one?
So the real practical problem with a full native production and requiring that is a few things. Number one, you can't bait stamp the documents. So you're going to be all over the place, not on the same page in depositions. You can't control it. Two, you can't control the dissemination of it out into the world. Native document can be forwarded on, it can be altered, authentication becomes a problem. So I almost always reject any requests and object in my RFP answers to a request for a full native production for those practical reasons. And that's just, it just really, it just needs to be a production for the most part in image file format with bait stamping and the OCR text in a load file and whatever the metadata fields are you agree to. As Arpit was saying, there's definitely certain document types that will agree to produce in native, like Excel, like PowerPoint, because those are different. Those don't render in an image file in a way that truly gives all the content all the time. So I think that's really the issue with native. I still get grumblings from, and look, full disclosure, I'm most always on the defense side, and I'm most always representing a corporate client. So we're almost always on the losing end of the burden stick there. So I still get requests from plaintiffs' counsel for a full native production, the argument being we should have the same access that you do to the data. And there's case law against that argument, and I've never really agreed to a full native. I think the only time we've ever actually done it is if it's a very serious government investigation and there's a true need from an investigative standpoint for native.
Do you ever get requests for forensic images of specific devices, and how do you handle that?
So those are again, really rare, and there's a body of case law where courts reject requests from an opponent for forensic images unless there's a showing, unless there's a need, such as allegations of fraud and actual showing that there could be something there. So I rarely get, in a civil context, requests for forensic images. And if I did in the civil context, we would object and only produce that if there was a court order, most likely. We do get forensic image requests from governmental bodies like the DOJ, of course.
Yeah. Well, I do some criminal practice, so it's more common both to seek forensic images and to be asked for them. I don't know if, Jessica, you have to deal with forensic images much?
If it's like a trade secrets theft or if it's a dispute about IP, and just to back up a little bit, a forensic image is basically, so if you have a laptop, you can take a file off that laptop and you can forensically preserve all the data associated with it, or you can take an image, so a bit-for-bit copy of your entire hard drive. And in that way, you see not just the files, but you see information on the hard drive where there's no longer a file, it's been deleted, but the information associated with that file might not yet have been overwritten by other processes that are going on the computer. So if you're, and Shannon talked about ephemeral data, if you're dealing with something like a breach response or a trade secrets theft, there could be more relevant evidence contained not just in the active files but in the deleted files. So there might be a reason to produce them or certainly preserve them in the event that you need to kind of get to that information down the road.
So often it's not what we get, but what we do not get, which is what is important. So let's take just about 15 minutes if we could talk about inaccessible ESI, that is to say what makes ESI inaccessible, how one avoids common mistakes for inaccessible ESI, and in general how to address inaccessible ESI, and that will bring us to just about 5:45, and then we'll have time for questions and answers. So we could start. Any one of our panelists, I think, could address the issue. So whoever wishes to take the ball.
I'll put in my 2 cents at the beginning, which is before you start down the road of arguing that something is inaccessible, talk to someone from the technical perspective. So whether that's the IT folks at the company, your advisor, or otherwise, you don't want to spend a lot of time getting everybody worked up about an inaccessibility argument if the truth is it's actually pretty simple or pretty cost effective or doesn't take too much time. And I've seen a lot of that. And not just sort of, to Judge Kirpalani's point, we don't want to be bothered with it, but a real true belief that it would be a burden or disruptive on the company when it's just not. So I would say start with sort of knowledge about the level of difficulty associated with doing whatever it is.
Well, I'd like to hear from the judges because inaccessibility, I've made those arguments, and really nothing's truly inaccessible. It's really a matter of how much money it's going to cost, right? It's really a proportionality argument is what it always comes down to for me. And so before I go on talking more about proportionality arguments, I'd love to hear from Judge Kirpalani, Judge Mason about, have you seen an actual true inaccessibility argument made in your courts where the data is just, no matter how much money you spent, it would be inaccessible?
Well, I will take the lead as Judge Kirpalani looks over to me. And the point that you raise is a very apt point. I suppose whether or not something is inaccessible first might be a question of fact. So that, for example, there may be a lost computer, there may be a corrupt file, and in those instances, something may truly not exist. In that regard, it is inaccessible. But generally what we see is just what you have suggested, Shannon, and that is to say that there's an unreasonable burden upon a party to produce certain documents. So there's one case that Judge Kirpalani had cited. It's one of our colleagues. It's the 2010 Superior Court case, the Markakis versus DeMellis case, in which the court found that there was an unreasonable burden where the plaintiff sought restoration of 22 years of backup tapes containing emails of over 13 of defendant's employees. That was deemed to be inaccessible. but truly it was accessible. But here we hark back to, under Rule 26C, this sort of proportionality test that we employ in determining whether or not information is truly inaccessible. So under 26C, the court may order discovery of inaccessible ESI if the party requesting discovery shows the likelihood that the likely benefit of its receipt outweighs the likely burden of its production, taking into account the amount of controversy, the resources of the parties, the importance of the issues, and the importance of requested discovery resolving issues. And if that sounds a lot like the proportionality requirement that we see in the federal court, it does sound a lot like the proportionality requirement, something that we did not purposefully adopt in the Superior Court, and candidly is still kind of out there. We're waiting to see what happens at Duke in August. I suppose they're going to have a conference, and they're going to report on the experience with proportional discovery. But we took the opportunity under Rule 26F, in particular subparagraph C, to address the issue of proportionality in determining accessibility. So, indeed, your point is extremely well taken. What is inaccessible may not really be inaccessible, but it may be inaccessible for that case, depending upon proportionality. So hopefully that answers your question and takes the heat off of Judge Kirpalani.
Yes.
Yeah.
No, thank you, and I appreciate that. So if what it comes down to then for me is proportionality, and how much is this requested discovery, no matter what it is. And I've had my own backup tape case where I thankfully was successful in arguing that it was absurd to spend $1.5 million to restore pallets of backup tapes that were kept in an uncontrolled warehouse shed in Alabama for an Illinois case that was only worth $200,000. I won that proportionality argument, thankfully. That was a little bit easier to make. A little more difficult, and since we've had the change in the federal rules that emphasize more proportionality, we've been using it more for your standard discovery request to argue that this scope of discovery you're asking for may technically be accessible. It's email, it's user data, right? But the scope that you want makes it not proportional with the needs of the case. And that's where some more advocacy work really comes in, because courts will not accept counsel walking in and saying, it's totally ridiculous for us to do discovery on 100 custodians. It's too expensive. That's not enough. You have to show with specificity each line item of cost that would show how much it would be in relation to the damages and the importance of the case and the factors that were mentioned. Just how far lawyers have to go to prove that point, to prove that something is not proportional in the cost, well, it's pretty far. I had a case last year where, and it was federal, I had to submit a 17-page affidavit with specific costs and line items. And the judge grilled me for about 3 hours about it. But it was helpful in the sense that we were able to control the scope of discovery, because the wider scope that our opponent wanted was not proportional with the needs of the case. One last point on this, and I think Judge Kirpalani highlighted, at least for the Massachusetts rule or federal, but there's a duty, and it's spelled out in the federal rules advisory committee notes, that the duty to appreciate proportionality is not solely on the responding party. It is shared amongst both parties and the court. And I think that that's an important thing to keep in mind, because a lot of times it comes down to the responding party, yes, having the burden to prove the cost of whatever this objected to discovery is, but the burden to show that the discovery being requested is proportional is shared amongst everybody.
You know, the difficulty that I've encountered as a judge in dealing with the issue of proportionality in e-discovery is that I'll get a case which candidly isn't for a significant amount of money, but all of the discovery is e-discovery. And the response that I get from the responding parties is that, well, this case just isn't worth our going out and engaging an expert. Well, then how else is the discovery going to be accumulated? Which is one of the reasons why we find bringing these matters to the bar are terribly important. And that's because so much of the information that we now are culling in discovery is all e-discovery in all cases. And let's not forget that Rule 26 doesn't just apply in the Superior Court. It applies in the District Court. It applies in the Boston Municipal Court, the Probate and Family Court, the Housing Court, etc. And so how one addresses issues of proportionality is truly a challenge to the extent that so much that we call upon in extracting and organizing ESI perforce needs to be done by an expert. And that's a great, and I appreciate Shannon indicating that. So why don't you pick up on that, because how do we address that issue?
Yeah, so I would push back on if litigants are telling you, Judge, well, this is e-discovery and that requires an expert and therefore it's too expensive, I would challenge that. I don't think that just because e-discovery, magic word, is used in your case, that it requires an expert. It's really actually simply not true. And frankly, sometimes cases involving e-information as opposed to paper is less costly, depending on what it is, right? So for example, I have a case right now that goes back to the 1940s, and about 90% of the information is wicked old paper records, and it's going to cost us a fortune to do all the glass work, manual glass work to copy that stuff. And I actually wish that most of the information was just run-of-the-mill email. It would be less costly, and I wouldn't need an expert. I actually do need an expert in this to deal with the old paper records. Yeah. And so sometimes if it's just a run-of-the-mill e-discovery case and it's just, email and some custodial data, you need probably a vendor who's adept at collecting it the proper way and putting it through the sausage-making machine and putting it on a platform to review. But the pricing for all of that is incredibly competitive now and low, frankly. And so I would challenge it in a case so if the response to you, Judge, is just simply, oh, this is e-discovery, therefore it's too expensive, I'd want to know why. Why specifically here?
That's a very valuable point. I appreciate that. Jessica.
And sometimes to the point of cost sharing, it goes the other way. And this is a very extreme example, but we had a case where our client was a company who believed that an employee had taken information from them. The employee basically said, well, it's inaccessible because I took it, I hit it with a hammer, and I threw it off a bridge. And our client said, thank you very much. We're actually going to hire the local law enforcement divers to get the hard drive, and then hired our forensic team to extract information from it. So our client paid to remedy the inaccessibility of it to their individual defendant, and we got stuff off the hard drive. So it depends on who is willing to shift the cost burden because of the value of the information in some instances. Extreme example.
Should have used a bigger hammer, right?
Yeah, right?
Well, speaking of hammers, one of the hot issues on the criminal side now is encryption, which we really haven't talked about. I have never encountered, in criminal cases, when you have clients who are being asked to produce things, or the government has to get information, it's a real issue. But I'm curious, I have never had to deal with encryption in a civil matter. I'm curious if any of my co-panelists have ever had an issue where you had a rogue employee who encrypted something, or somehow or other you dealt with that encryption issue.
I mean, I have all the time, but you guys do.
I mean, we deal with the fact that we need to go through the decryption process and the cost associated with it. So, I mean, we deal with a lot of projects just as standard where whether you'll have a password-protected Excel file. Right? That is a form of encryption, or you would have a certain folder that's just been completely encrypted, and you either can take the easy route of ask the user for specific passwords. So when we do custodial collections, we will have a step that we'll say, are there any commonly used passwords for things that might be in this folder that we're collecting that we need to be aware of, which makes machine time a lot faster because we can just feed in the password. But if the password is not available, then there are still, tools that will help you just iterate through pure machine force, try 20 million different passwords, and hopefully one of them will stick, right? And that's why you always get recommendations: don't put your date of birth as your password, or don't put, easily accessible phrases as your password, because that's the first thing that those password cracking tools try to get at. We do obviously see a lot of these cases where, as standard, we will not go through the decryption process, but then you would get a report that's signed out, and then should it reach a level where it becomes important and it is on part of a machine where something important would have lived, and you want to spend that extra resource to try to decrypt it.
All right, that leaves us with just about 15 minutes. We're right on schedule for your questions. This is a valuable opportunity for you. Please don't hold back. No question's a bad question whatsoever. But we have a team of experts before us, which is of national renown. Please take advantage of it. Yes.
How you doing? I was just curious. The idea of competent representation came up. And I was just curious how, or is there a guide out there or something that you would think would be obtainable to become more competent in this area? Because obviously, despite learning a lot in this last 2 hours, this is a vast area of law. I was just curious if there was anything available out there to attorneys to purchase or get, something like a mass guide to evidence, for example, as a parallel to become more competent in this area of law.
Well, I'd say, I think, Judge Mason, you referred to the Sedona Conference.
Absolutely, yeah. Wait, do you have the name of it? It's probably about 150 pages or so.
Well, they have a number of publications.
Yeah.
Just go to their, I would say go to the Sedona Conference website, and you will find, basic materials on e-discovery. Sedona is sort of a think tank that works on different legal issues, but e-discovery is definitely in their wheelhouse. And go to sedonaconference.org. You can join. It's about a $350 a year fee to become a member, but well worth it. Their work on e-discovery is invaluable. And so if you wanted to start somewhere, that's what I would recommend. I don't know.
Yeah, I think that's a good resource. I also think EDI has video educational series. Just look up EDI, e-Discovery Institute. And you can pick amongst different video modules for education. Also, since you're a Suffolk grad, you could comp the spring course at night that they teach. I'm not doing it, but my friend is, and it's a good course.
Yeah.
I'm just wondering, kind of as a practical matter, is one of the things you're basically saying is that nowadays a litigator pretty much must have an e-discovery vendor in every case? Is that now kind of like the baseline?
Yeah, no, I definitely don't think that that's the baseline for every case. Not at all. I would say it depends on the size of your practice. So if you're a solo practitioner, depending on the size of the cases you have, I think economically you're better off probably having one of the smaller regional vendors that host in the cloud, that you could probably come up with some kind of good economical pricing arrangement with to host data for you for your typical reviews. If you're a mid-sized firm up to your large firm, you might want to do some cost comparisons of bringing in your own software behind your own firewall for review platforms, or leaving yourself open to using one or two different vendors who would host for you and process for you. I think a lot of mid-sized firms, I'm obviously I'm at Rose, so it's a different set of options that I have, but mid-sized firms, if you don't have a litigation technology support within the firm, so like that really specialized paralegal, you probably want to think about talking with some area vendors who you get comfortable with, who can help you with processing information and, collecting information if you need that. But do you need a vendor on every single case? You don't. It really is going to depend. It depends on how much information you're collecting and you need to review and get through.
For example, you may have a client and they have a cell phone that they use, and the opposing counsel requests, information, texts, emails, things from the cell phone. You can try to work that out with them, and so you can give them screenshots or whatever. But in the end, you may need a vendor who can really certify that the information you're turning over is everything they're asking for, including metadata. So unfortunately, there is a large role for vendors these days.
Tangentially, for e-discovery disputes, something I can personally say, and I perhaps speak on behalf of myself and Judge Kirpalani, we loathe, you would do well on the more complex discovery disputes to think about an e-discovery master, okay, to weed through the volumes of materials. And for those who are looking for new avenues of enterprise within the legal profession, that would be a really good place to go. So, other questions? Yeah.
First of all, thank you all very much. It was really informative, especially for the people who traveled. I have two questions, actually. The first is, what are good practical tips for ferreting out modifications and deletions of files and documents? I know we briefly touched upon that, audit logs and things like that. And then my second question relates to the presentation of this topic, particularly when it comes to the fact finder, to juries, things of that nature. Are there practical tips that you could give to us for explaining these things to members of juries, asking for particular instructions from judges, things of that nature?
I can quickly address that second issue. Less is more, particularly in front of a jury trial. No juror wants to see an excessive amount of, for example, emails come before them to be presented for analysis. The benefit to you is in presenting something that is accurate and something that is complete. But the cost in doing so is the overwhelming amount of information that is presented. Summaries, which are generally admissible under the Guide to Evidence, and I would commend you to the particular section, are a great way for you to organize information. But remember that fact finders, whether or not they be judges in a jury waive setting or jurors, are not generally going to be sophisticated in ESI. So you need to truly, for myself principally, dumb it down so that we understand what you're talking about and make it simple. Those are the most powerful ways to address these issues at trial. Judge Kirpalani, what are your thoughts?
Yeah, I would agree with that. You do not want to overwhelm the jury with your ESI. So data summaries or compilations may be one way to go, depending on what the data you're talking about is, or just pulling out the truly relevant, if it's emails or something. I've seen cases where the jury was presented with juror notebooks about this thick with thousands of emails in them, and then of course they only highlighted a few during the evidence, so it was really a pointless and also intimidating experience for the jurors, and unnecessarily so. With respect to the courts, yeah, I can't stress enough that We don't see these issues all that often as judges. I have a theory that the litigants are scared to bring them before us, and they work things out, and that's why we don't see that many motions about e-discovery. But if your controversy, I mean, we get it when somebody takes a sledgehammer to a BlackBerry or something, but if your motion or your controversy involves words like custodian and metadata and native format, you have to assume the worst, that we have no idea what you're talking about. So you have to educate us as well as a jury and dumb it down. So simple is better. And that goes from discovery motions to trials. I mean, if you're asking us to resolve a dispute that you haven't been able to work out, you have to educate most judges first.
Also, we require final trial conferences in the Superior Court, that is to say a week or two prior to trial. Raise issues that may present evidentiary hurdles. Hearsay issues. Is it computer stored? Or computer generated. Okay, a computer generated piece of data may be an ATM receipt. That's not hearsay. Something that is computer stored in email may very well be hearsay unless it otherwise fits within one of the exceptions to the hearsay rule. Take a look at Section 801 of the Guide to Evidence in that regard. Authentication issues are big issues. Take a look at Section 901, in particular the Purdy case, that is our seminal case pertaining to authentication and determining confirming circumstances, so to speak. And then lastly, take a look at Section 1002, the best evidence rule, which doesn't preclude the admissibility of computer records under the best evidence rule. Raise those issues at final trial conference. Otherwise, what will happen is when they perk up in the middle of a trial with an unwitting judge sitting there, you're going to freeze the action. But those can be really thorny issues. Take a look at the Guide to Evidence. It's one of our bench books and probably the best place to look relative to ESI. Modifications. Why don't we turn to the panel now to answer your first question?
So it depends. There's a whole spectrum of things that, whether it's inadvertent, which happens probably most frequently, so someone has failed to preserve, collect, turn over, accidentally deleted data, that is more frequent, and that's usually easier to spot because it happens more in aggregate. So you can look at a custodial production, you can just see, there was 15 emails on this day, and then it fell way off, like what's going on there. So some of those things are inadvertent. With respect to specific manipulation, usually it's something we could go back to the forensic image example where you're actually looking in detail at records of deletion, file artifacts, pieces of files, browser history, system data that could indicate what the user was doing on the machine. If you're talking about like a native file that someone's trying to pull off as actually authentic that isn't, then sometimes you're falling back on, did you have an authentication protocol in place? What was the hash value that Arpit mentioned earlier? So basically the digital fingerprint of the document, and can you authenticate through the chain of custody, through the collection processes, that was how it existed in the normal course of business when you collected it. And then some basic tools are available, like Arpit talked about the conversation history. So if you and I exchange an email, there's a piece of metadata that's stored that says every time we send something back and forth, it appends to say this is the 15th email in this thread. Now, if I send it back to you and I delete the full middle or I change it, then the computer doesn't know to start a new thread. It keeps appending. So you can see instances where two versions of an email have the same identifier to indicate that they happened at the same time, they were part of the same thread, but one has different text content than another. And that discrepancy is something that you could derive relatively easily programmatically if you knew to be looking for it. I mean, I would say that as a matter of course, we don't go into every case and say, show me every scenario where the same thread has different text, because you could have a lot of good reasons for doing that. But there are there are artifacts like that that are in the metadata or in the document's normal properties, like Shannon mentioned her case with all the executives contributing. Office documents track those sorts of changes, so you can sort of dig down and say, well, I know that the date on the face of this document is December 5th, but you can see the change history continued well past that date, so someone is making this look like this was the date of the document. Or you can compare sort of different versions of the same document that exist across different individuals in the population. So there's a lot of different ways you could go at it. It really kind of depends on what you're trying to prove.
Well, that takes us just to 6 o'clock, and I want to thank our panelists, Judge Kirpalani, Jessica Block, Shannon Capone Kirk, Andrew Levchuk, and Arpit Bothra, who have, in many instances, traveled far. We greatly appreciate all of your commitment to this important issue. I'd like to thank Mike Soperito, the CLE coordinator here at this venerable institution, John, our tech guy, but most importantly, I want to thank all of you for demonstrating an interest in this important topic. And I do want to thank some other people, and that is to you, the virtual viewers of this particular program. All programs here at the Social Law Library are recorded for now and for time eternal. Any member of the Social Law Library can access this particular program. This is a very important program. Make no mistake about it. We're not talking about necessarily cutting-edge issues. These are issues that have been around for some time, but issues which many of us, judges included, lag significantly behind in understanding, but issues which we must understand if we are to deal with conflict resolution, and in particular litigation in the 21st century. So I hope that you'll tell your partners, your associates, your friends, your colleagues about the availability of this program and spread the word as to its availability so that people can enjoy it while sitting at home on their iPad, on their iPhone, or whatever portable device they may have. So once again, thanks and have a great evening. And please fill out the evaluations. Thank you.